Good evening. Tonight I'm going to look at how you can obviously meet the migration rules for the purpose of bringing adopted child to the UK. For those of you who have been following us, you would have realized that 2 months ago we looked at how you can bring your child to the UK even if you have limited leave to remain, which means that those who don't have permanent stay, they may have 30 months leave to remain based on various grounds, whether their child has been here for 7 years or they have a British child. We looked at how those people could bring their children to the UK under the immigration rules. Tonight I'm going to look at a very complex area of both the family law and immigration rules, and I'll be looking at how you can bring your adopted child to the UK. So in looking at this, I'll be looking at various areas of the law because there are various laws, orders and regulations in place that guide adopting a child from, especially abroad. I'm sure that most of you living here are almost familiar with the law regarding adoption, which is the Adoption of Children's Act 2002. But my interest tonight is looking at those different jurisdictions where people may want to bring adopted children from, and then obviously to also satisfy the immigration rules. So I want to urge you to share this video, obviously inform those who have interest in this topic to join us tonight so that we can have a very, very interactive discussion on these issues. Now, I must start by saying that whenever someone wants to bring a child to the UK, some form of the immigration rules needs to be satisfied. So obviously, if those immigration rules are not satisfied, then those applications will be refused. But the sad aspect of it is that most of these applications are very, very, very expensive. So it's important that people get it right. Because when people don't get it right, that child involved becomes frustrated. That parent wastes their money and they become emotionally devastated. But day in, day out, people are still making mistakes because they are not familiar with the law surrounding some of these topical issues. And it is for this reason that tonight I'm going to slowly take viewers into those areas that may be stumbling blocks, obstacles to bringing these children who may be their de facto or they may be adopted children or children that they have intention of adopting and obviously bringing them into the UK to join them. So to start with, I would want to look at the adoption procedures regarding 3 areas or looking at 3 jurisdictions. And eventually, I also looked at when people have been unable to go through those adoption process and they say want to bring those children, is it possible for them to rely on Article 8 of the European Convention? Is it possible for them to rely on compassionate or exceptional grounds or circumstances in the light of the fact that the UK, under Section 55 of the Borders Act, have a duty to protect the interests of children globally. And therefore, tonight, the first thing that people need to take into account whenever there is that intention to adopt a child, of course, if you are adopting a child and the child is remaining abroad, then there is no problem. But if you are adopting a child with the intention or the purpose, sole purpose of bringing that child to the UK, then there are rules that needs to be satisfied. And these rules can be found in the immigration law under paragraph 316. But having said this, the rule sets out the requirements that need to be met in order for that adopted child to be granted entry clearance to the UK, or for the purpose of that child being granted some form of visa to enter the UK in order for that child to be adopted in the UK. And very soon I will make viewers aware why some children cannot be adopted abroad and why some children need to come and complete that adoption process in the UK. Now, first and foremost, the starting point of looking at adoption law is looking at the Hague Convention 1993 under the section 23. Clearly sets out, and if you look at the UK regulations, you realize that under the Adoption Recognition of Overseas Adoption Regulation 2013, this law came into force on the 3rd of January 2014. Now, this law clearly lists the countries where UK recognizes their adoption certificates. Now, in Africa, there are about 3 countries: Burkina Faso, Mali, Guinea, and some few other countries. Sadly, Ghana is not in the list of these countries. Neither is Nigeria or Cote d'Ivoire. And that's why it's so important that people need to be mindful so that they don't throw away their monies. So under the Adoption Recognition of Overseas Adoption Regulation 2013, which came into force 3rd of January 2014, it clearly sets out that if you adopted a child, of course, that adoption might be valid in that jurisdiction. So you might decide to adopt a child in Ghana using the Ghanaian law. You may decide to adopt a child in Nigeria using the Nigerian law. You might decide to adopt a child in Cote d'Ivoire using the Cote d'Ivoire law. But the law that I have just quoted clearly says out that because that country is not listed in these countries that I have just mentioned, clearly means that that order or adoption certificate is not recognized by the UK because it is not a country listed under the Hague Convention. And that presents difficulty to couples, families, with the sole purpose of obviously adopting these children and bringing them safely to the UK, because some of them have spare rooms, they need these kids badly to be part of their family, and they have made all the provisions for them in the UK. But the law becomes a stumbling block because these jurisdictions or these countries are not listed in the Overseas Recognition Regulation law, which came into place of 3rd of January 2014. So which means that people need to take into account whenever there was that intention to adopt a child and bring that child safely to the UK under the immigration rules. So quite quickly, somebody may ask, or someone will ask, so lawyer, if my country is not listed in the Hague Convention list of countries, which means that under the Adoption Overseas Recognition Adoption Order 2013 regulations, if my country is not listed there, which means that my country falls out of this country or the list of the countries. What do I do? So it means that you will still have what they call the inter-country adoption procedure or process to follow. So obviously, you need to still follow the inter-country adoption process. But this is the point. And if I use Ghana as an example, because I love my country, Ghana is not in the list. Therefore, if, for example, you intend to adopt a child from Ghana, and in practice, I've seen people, sometimes they come to me and I'll tell them, I won't do this job because I know this job will fail. You can find other lawyers who are likely to do it. And in fact, they find lawyers who do it for them and then they end up wasting all their money. Because if you have the understanding of the law, then before you even accept that adoption certificate issued from Ghana, you should know that that application will fail. So the question that people should ask themselves is that, why is it that people still use these adoption certificates and make applications in a full knowledge or ignorance that those applications are going to fail? And of course, these applications are very expensive. They cost a lot of money and preparations. So if, for example, you are adopting a child from a country such as Ghana, which is not in the list of the Hague Convention countries, then the starting point is you need to establish, again, here we have the Adoption Act 2000 Order 2002. We have the Children's Act and Adoption Act 2002, which sets out under Section 833 what should be done and what local authorities should do. And obviously, there is also the Regulation 2005, which also talks about adopting a child from a country which is not listed. It means that under those circumstances, one needs to contact the Department of Education and establish an agency who will be in charge of making those assessments, because obviously you cannot just go and adopt a child without offering yourself to be assessed by the relevant authorities, because in the end, remember that you could be charged for child abduction. So in most cases, if your country is not listed in this list of countries that I've just mentioned, then the starting point is for you to be in touch with an adoption agency who will then liaise with that country to set the ball rolling. But under those circumstances, when these two agencies, either the one in this country under the Department of Agency, recognized adoption agency, and the one in Ghana, for example, if I should pick Ghana as an example of the countries where people want to adopt children from, then once those assessments have taken place, you will not get a final order, because I've said that if you make that order there, or if that adoption order is made in Ghana, I have already explained why that order will not be recognized. And not just Ghana, a list of the countries who fall outside these countries that I've just enumerated. So under those circumstances, you will not have the order being completed in that country. So someone will ask me, what do I do if I want to bring the child to the UK? Again, there is provision under the immigration rules which allows parents or couples in those circumstances to make application for limited leave to enter. Because the point is that if someone adopts a child in a very lawful manner, which is, and I'm choosing my words carefully, and that adoption order or certificate is recognized either under the UK jurisdiction or under the Hague Convention, then if that person has an indefinite leave to remain, that child comes in with indefinite leave to enter. But of course, when I'm talking about a child, I'm looking at children under the age of 18. But having said that, If your country falls outside this list of countries, then of course, as I've already explained, these orders cannot be conclusive in that country. So under those circumstances, the provision under the immigration rules is to allow you to make application to bring that child here. Remember, at this stage, you have not concluded the adoption proceedings. And you haven't done that because even if you concluded the adoption process in that country, for example, Ghana, it will not be recognized because of the aforementioned reasons. However, you will be entitled as long as you've been assessed by adoption agency, both here and in the UK, and the background of the child has been established. Then, of course, at that stage, you will be entitled to make an application to bring that child into the UK. But that child will not be entitled to indefinite leave to enter, because at this stage, you have not concluded the adoption process. So when the child comes into the UK, wherever you live, you have 14 days to notify that local authority who has a duty towards that child of the arrival of that child and the home where you live with that child. Of course, if you don't do that, I'm sure most of you are already aware where I will be going with this. There could be sanctions. But once that has been done, that it means that at this stage, you are going to be able to conclude your adoption process in country. Because if you did it abroad, it will not be recognized. But having said that, there are other ways where these two procedures that I have just explained do not fall within the areas which is convenient for you watching me in order to apply it and follow those processes and bring a child. So you probably have to listen to the third option, which I have for you. If any of these two options, I'm sure when I do my summary, I'll be able to explain this again, because I know this is quite complex. It requires you to be attentive and listen carefully as I choose my words very, very carefully in order not to confuse you. But having said that, if these two options, which is adoption under the Hague Convention, adoption in a country which falls outside the Hague Convention, and by this I'm looking at, obviously, adoption, recognition of overseas adoption regulation 2013, which came into force on the 3rd of January 2014. So when I talk about the Hague Convention 1993, section 23, I'm looking at this particular regulation. I've also looked at Adoption and the Children's Act 2002, and I've explained the local authorities' duty when children are brought to the UK who are in the for the purpose of coming to the UK for adoption, and those who are adopted in the countries that are listed. Now, the last option is for those who cannot make use of any of these options. The question is, where do these people seek advice, or what sort of legal framework is there for this category of people who do not fall in any of these two terms that I've just explained? Now, I'm sure that you are going to be patient with me whilst I take you through this. Now, the third option is what I will call de facto adoption. Now, I'm sure that my terminology might be a bit confusing, but when I say de facto adoption, I am simply saying that you have lived with that child has become your own in that jurisdiction where you have been living. And in fact, you may not have documentation to show that you have adopted that child, but all facts point to the fact that the child has always been in your care, at least for some years. And therefore, under those circumstances, you might be able to treat that child as if that child is your adopted child and you being adoptive parent. So that's what I mean by de facto adoption. Now, so with regards to de facto adoption, as I've already explained, you may not have that the documentation to show that you have lawfully, legally adopted that child. However, the circumstantial evidence points to the fact that that child obviously more or less looks like a child of your own, because you've been doing everything genuinely as a parent of that child, even though you are not the biological parent of that child. So that becomes what they call de facto adoption. And I'm sure that a lot of you watching me will be asking yourself, where do I go with this de facto adoption? Now, there are a lot of you who may have siblings, you may have children of your siblings, you may have family members that you have been doing everything in terms of taking care of them. Now, some of you are British, you might even lived outside the UK for some time with these children. Now, there was a time when one of my clients, potential clients, called me and said that, look, I want to bring my family, but I have this person who has always lived with us, and he has always been part of the family. And of course, he has always been recognized as our child, but she is not. And we don't have any documents to show that we have adopted this child. What do I do in bringing this child? Because if I'm coming to the UK, especially if I'm coming with a skilled workers visa, then I don't want to leave this child behind. So it means that this child could be treated as de facto adopted child. Because obviously, you might have been the one looking after this child in school, you might have been the one feeding the child, you might have been the one taking the child to hospital whenever he's sick, responsible for paying the bills. And everything points to the fact that even though that child is not your biological child, you are the one that has been charged of doing everything that concerns that child. And that becomes a de facto child. And I'm sure most of you will find yourself in this position. I know most of you are here who are taking care of your siblings, taking care of your children, siblings' children, various children, your nieces and all that. And I'm sure that some lawyers will tell you it's not possible. But I'm telling you that as long as there is circumstantial evidence that that child can be treated as de facto adopted child, then there is provision in the immigration rules for that child to join you in the UK. So you see that I am trying to conscientize you to be aware that it's not only biological children who can be brought into the UK, or it's not only those who have been legally adopted who can be brought into the UK, or it's not only those who have been adopted under the Hague Convention. And as I've said, if you have just joined me, obviously when it gets to my summary, I will take my time to explain all these things that I have said so that people can benefit. But having said this, having looked at the three areas of either bringing adopted children to the UK, or the areas involving how one will adopt a child from a foreign jurisdiction and bring that child to the UK, or how somebody will bring the child to the UK and then adopt the child while the child is in the UK. And I'm sure that most of you would have heard that, oh, it's not possible to bring a child to the UK and adopt the child here. I am talking about the law. Whenever I come on this platform, I don't give fiction, I give facts. And that's why whenever I speak, I make sure that I support my utterances with the relevant legislations and the acts in place so that people can check these facts for themselves. But having said this, let's look at the entitlement of that child in terms of how that child will gain entry to enter the UK. Now, the first point is that if one is British, if a couple, one of you is British, and you have adopted a child from foreign jurisdiction or from overseas, then under the section 1 subsection 5 of the British Nationality Act 1981, quite clearly, that child is also automatically British. So I want to repeat it here. Whenever you are successful in adopting a child from a foreign jurisdiction in a foreign country, then once that child has been adopted, either through the Hague Convention or either through the inter-country adoption proceedings or either through de facto adoption, then by virtue of the fact that you are a British citizen or national, that child whom you have adopted under the British Nationality Act, Section 1, Subsection 5, that child will be automatic British. So you are passing your nationality, your citizenship to a child who is not your biological child, because this child has either become your de facto British child, adopted child, or he has become your adopted child. Now, so having said this, let's look at those who have, for example, indefinite leave to remain, who want to adopt children and bring them to the UK. Now, what is the entitlement of that adopted child in terms of that child's entry to the UK? Again, the benefit of that you having the indefinite leave to remain and adopting that child from abroad is that you will be able to offer what you have to that child, which means that that child, under paragraph 316 of the immigration rules, that child will be able to enter the UK with indefinite leave to enter. So when that child is adopted, either under the Hague Convention or through inter-country adoption proceedings or through de facto adoption, then obviously, because of the fact that you have indefinite leave to remain or settlement, that child comes to the UK with indefinite leave to enter. So these are the rules that falls under the immigration rules and the British Nationality Act, and then the Children and Adoption Act 2002. But let's look at what is in there for the EU nationals, because obviously the EU law is still part of the laws in the UK. Even though the UK have left the EU, we still have most of these laws still operating. Now, from the beginning of my submission or my discussion, I made it clear to viewers that whenever you are looking at a child, we are looking at someone who is under the age of 18 years. But quite interestingly, under the EU law, this age definition is different. And again, I want people to take very good note of this. So which means that if you are an EU national and you are adopting a child, now quite clearly under the adoption guidance immigration rules, it says how that under Regulation 10 of the 2016 EU regulations, a family member or a child who is a family member is a child under the age of 21. So for those of you who have children who are still under the age of 21 and have EU citizenship, it means that or for example, if you want to adopt a family member who is under the age of 21 and is above 18, you still have the opportunity to adopt that person. And that person will still be treated as a child. And of course, I must create distinction here because I normally give very, very comprehensive advice. I am not talking about extended family members. So I don't want people to misquote me that I sat here and said that extended family members could stay, because normally when people hear of adoption, the first thing that comes to mind is extended family members. I'm not talking about extended family members tonight. I am talking about people who can be legally and lawfully adopted, and those adoption certificates being recognized under the Adoption Recognition of Overseas Adoption Regulation 2013. That's what I'm discussing tonight, which connects us to the Hague Convention 1993 under the Section 23. So what I'm saying here is that for those of you who are EU nationals, who have the intention of adopting family members or people that I may not want to call them children, because these people are within the ages of 0 or 1 to 21. So under the EU law, a child is somebody who is under the age of 21. It means that every single thing that I have discussed here on this platform regarding adoption under the Hague Convention, adoption intercountry, adoption proceedings, de facto adoption, all these still come into play. So it means that most of these extended family members indirectly can be treated as de facto adopted children if those extended family members are less than the age of 21, which clearly says out that applications can still be made under the EU Family Permit Scheme. And I'm sure I'm being a bit legalistic here, so I'm going to take my time to say this again. I have already set out the process of adopting a child. I have looked at 3 areas of looking at the law. The first area is adopting a child from a jurisdiction which is listed in the Hague Convention, or a country that is listed in the Hague Convention. And based on the Hague Convention, the UK has what they call Adoption Overseas Recognition Adoption Regulations 2013. This order came into force on the 3rd of January 2004. And I'm sure that there are a lot of you, perhaps even watching me tonight, most of you made application in the past with Ghanaian adoption certificates. And that law was quoted for you. And most time people will come and ask me, oh lawyer, what does this mean? What this means is that that country, which is Ghana, is not listed in the list of countries in the Hague Convention. And therefore, adoption certificate from Ghana is not recognized under UK law. But I've said that if you don't fit within any of these laws, there is also what they call de facto adoption. And this de facto adoption clearly points to people who could be treated as extended family members. And I've said that, though under the previous regulation, extended family members are siblings who are more than the age of 21, nephews, nieces who are more than the age of 21, who can show financial dependency. But tonight, I am talking about those who are de facto adopted children by virtue of the fact that they are catered for by these EU national family members. And also on the basis that these people are less than the age of 21. So it's on this basis that people can make applications under the settlement scheme using the de facto adoption route to make these applications. And I'm sure some of these things are quite complex, but obviously I always urge people to seek advice with this preliminary advice that I've given on this platform. Now, I have looked at this adoption process, the laws, the jurisdictions, and I've also looked at the immigration rules, paragraph 316. But because the rules restrict entry grounds for these children that have just explained, or this adoption process, the rules restrict applicants to satisfy these requirements, which is what I've just explained. Now, I am taking my time to let viewers be aware that even though I have been quite flexible and giving definition and what it entails for de facto adopted child, there are other grounds that people can equally make applications if they don't meet the immigration rules under paragraph 316. Because I've set out that when you are making application to bring in a child for indefinite leave to enter, you either have to have adopted that child lawfully, and that certificate is recognized by the UK law, or you have to use the inter-country adoption process and bring that child to the UK and complete the adoption in the UK, or rely on de facto adoption, which is where you provide circumstantial evidence of how you feel that you have adopted that child based on the evidence you have, even though you don't have documentary evidence, legally, to show that you have adopted that child from the relevant jurisdiction. So the rules will set out these requirements to be met. But if you don't meet the rules, you are not able to adopt this child. But however, you probably may have something close to de facto adoption evidence. Then I am going to take my time to explain to viewers three other options which fall outside the immigration rules. Because as I've said, the rules are quite strict, and therefore if you don't meet the rules, it's most likely that your application will be refused on the basis that you don't meet the rules. However, the rules have been made in such a way that caseworkers are obliged, they have a duty when a child's application is involved, to look at what they call exceptional circumstances, to look at what they call compassionate factors, to look at the Article 8 of the European Convention with respect to family life and private life. And therefore, you may be watching me tonight, but any of the three things that I've said doesn't solve your problem. But obviously, you also have the intention of bringing a child who is not your own to the UK, because either the parents have passed away, either you are the one responsible for looking after them, whether their parents, one reason or the other, are unable to look after those children. And I want you to know that there are still options. Though it might seem quite elusive, but there are options. As I've said that if you don't meet these requirements, when these applications are made, you need to plead what they call exceptional circumstances. So under these circumstances, you are saying that this case presents a unique circumstances because of perhaps the risk to the child, because of the fact that that child needs your care, because of the fact that perhaps the parents of that child is no more. Perhaps the child with social services report shows that accommodation and other facilities for the child's care is not inadequate. So you are presenting quite unique and exceptional circumstances for the caseworker to consider that in the absence of meeting these migration rules, that child is still entitled to come to the UK, even though you might not meet the requirements under the adoption guidelines that I've just explained. And the last option is what they call compassionate factors. Now, it might mean that these exceptional circumstances and the compassionate factors are always intertwined in the sense that they overlap with each other. However, the difference between the two is the fact that with exceptional circumstances, caseworkers are obliged under the European Convention that even if it's not raised in the application, they are obliged to say, consider it. And I'm sure that most of you, when you receive your entry granting visa letters, the caseworkers will always say that having looked at this condition after the immigration rules by looking at the Human Rights or the Article 8 Convention, you say do not meet. The reason they say that is because they are obliged to consider it. But most of you do these applications on your own. And therefore, instead of presenting that circumstances, for example, a parent who is not working and does not meet the maintenance requirement, who wants to bring his or her child to the UK for indefinite leave to enter, because that parent cannot meet the immigration rules, because that parent cannot certify the maintenance. The maintenance is different from the financial requirement, which is popularly known as 18,600 and above. But if that parent does not meet the maintenance requirement, then it means that you need to rely on what they call exceptional circumstances. But this needs to be known to the caseworker who is considering these cases. And as I've said, they are obliged under all circumstances to consider it, even if it's not raised. But if you paint a good picture, then it makes that case even much stronger. Now, having said this, the compassionate grounds are grounds that are quite distinct in terms of caseworkers' obligation to consider these factors. Because I've already said that one of the factors comes under the Article 8, which is the right to family life and private life. And therefore, any exceptional circumstances, whether raised in the application or not, caseworkers are obliged to consider them. However, for compassionate factors, they are not obliged under the guidance. So again, it is you who need to present this vulnerability that a child is having, the risks of, or the likelihood of risks of harm to this child, the fact that these factors makes it quite obligatory that under the duty under Section 55 of the Borders Act, the UK or whoever is representing the Secretary of State for Home Department is obliged to take these factors into account. And it is for this reason that most applications are refused, because these factors are normally absent in most of the applications. So tonight, it's been a privilege coming your way with this new adoption guidance by looking at all these various areas that obviously I'm sure somebody watching me will fit into one of them. As I always say, every advice given on this platform by our disclaimer is for guidance only. And therefore, I always urge people to seek proper legal advice. But if you don't have a lawyer and you want to come to Citilaw Solicitors for us to assist you regarding any of these things that I have discussed, I know some of you have already been in touch with me. If you know anybody that you want to get substantive advice on how to proceed with application of this nature, we are willing and able to assist. Now, obviously, if you permit me, this is the time that we need to sell our sponsors. And the only sponsor for now is Citilaw Solicitors. So I'm going to advertise the sponsor or the sponsor's business, and then after that, I'll be able to summarize. But whilst I'm doing all this, if anybody has a question about any of the things that I have discussed, then obviously I am willing to answer those questions. And the phone lines are there, so you can call me if you have any question that you want to ask regarding what I'm discussing tonight. So for those of you who may want to call in, the phone lines, as I've said, they are on the screen. But in the meantime, I want to take opportunity to advertise Citilaw Solicitors, who are the sponsors of this program. And it's important that we advertise. So just bear with me as I go through some of the stuff that Citilaw Solicitors does. And I'm sure that most of you may need some of this service, because I always say that it's not just immigration, even though immigration is one of the areas that we enjoy assisting people with their problems. But obviously, there are numerous areas of law that Citilaw Solicitors can also assist you with. So tonight, I'm going to take the opportunity to advertise Citilaw and obviously make sure that all of you can benefit from the numerous areas of law that Citilaw Solicitors can support you with. In the meantime, may I take opportunity to acknowledge some viewers, lawyer viewers, of course, who have been on the platform all the time. I have Choma Sorrell, so well done, my people. I have Kofi Amwaten, who is always here to support the program. Say good evening, lawyer. I have Tina Tamakru all the way in Ghana, who is always here to enjoy the program. I'm sure that you've been able to learn a lot, which is nice. This is a very, very educative program, and I urge you to share with your friends and family members, because I'm sure that people will benefit. Citilaw Solicitors, we are here to create this awareness so that people know their right. So it's very important that those of you watching obviously assist us to fulfill that corporate social responsibility. So if you want me to acknowledge you, I urge you to put a comment, then I can acknowledge you. Now, this is the time that Citilaw Solicitors needs to advertise its business. Now, Citilaw Solicitors, if you are looking for us, we are big. You can find us in Barking. Our office address is 50 Cambridge Road, Barking. The building is Barking Enterprise Center. It's very close to the Barking station. So once you are at the Barking station or near Asda, you can easily find Citilaw Solicitors just at the Barking Enterprise Center building. Now, we specialize in numerous areas of law. And obviously, sometimes I'm tempted to say that it's a solution center, because we provide numerous services to our clients. Now, we specialize in immigration. That is the reason why I have been here tonight, taking my time to explain to people the new adoption guidance. The reason why I call this the new adoption guidance, Home Office withdrew the guidance since around 2018, and therefore it's been in such a way that I don't know whether it was done deliberately or not. But now we have a guidance in place. And the reason is that when you have a guidance, I'm sure those of you who have made application under Zambrano and all these applications will know that because there are no guidance, it's always difficult for caseworkers to make decisions. And in fact, sometimes they cannot even make decisions, like these Zambrano cases, who are, say, waiting with all the uncertainty that we don't know what may become of it. But that is not what I'm discussing tonight. But I am saying that there is this new guidance, the adoption guidance, which is what I have taken my time to explain here. So Citilaw solicitors, we don't just come here to talk about just immigration. We make sure that we bring quite unique areas of the immigration rules. And the reason I say this is the fact that I have been on this platform advising clients how they can regularize their stay by relying on non-biological child. I've been on this platform advising clients on how they can let their children living abroad to join them, even if they don't have indefinite leave to remain. So it means that those of you who have just this 30 months, you don't have to wait. You don't have to wait until you get indefinite leave to remain. And of course, perhaps, I'm sure some other lawyers are now talking about it, but we have discussed this in about 4 weeks ago, because we always want people to be aware of these obscure rules that are not in the mainstream. But those are the ones that are so beneficial to those people whose children are stuck abroad and they think that they don't have that right to bring them, simply because they don't have either British or indefinite leave to remain. And that's the more reason why we do this program, for people to know their rights. Because most of these people who might not even be our clients anyway, but it is important that these people know their rights. Now, having said it, we specialize in nationality, asylum, and all areas under the immigration rules, including the famous EU law, which is still under the settlement scheme. And we're still dealing with applications, late applications. So if you have any other immigration problem, don't go far. Citilaw Solicitors is your last stop. Now, we specialize in employment law. Now, employment law, we do all cases under what they call conditional fee agreement. Now, what that simply means is that if you lose, we lose. So you can imagine, it means that whenever I'm taking a case, I assess the case very carefully because I don't want to waste my time and your time. But when I pick up the case, then obviously there is a likelihood, very, very high likelihood, that you are in for that money. And Citilaw Solicitors only just paid a token. And our team of solicitors are there to assist all of you in these areas of law. So if you have any employment law problem, those of you suffering discrimination at the workplace, being dismissed because you are less than 2 years, those of you going through harassment in the hands of some of the managers and colleagues at work, those of you who have been unfairly dismissed, those of you going through redundancy, somebody called me and asking, oh, this is the calculation that has been made for me, and I feel it's wrong. I said, yes, it's probably wrong. But when you get your settlement agreement, bring it to us. People don't know. Normally, when the employer gives you that settlement agreement, by law, they are supposed to pay the lawyer who looks into it for you. So we get paid by your employer by looking at your settlement agreement, especially for those of you who are going through the redundancy. Having said that, we also specialize in the family law. Now, last week, a lot of people told me, oh, we didn't know that the law was going to change. Yes, this is what Citilaw Solicitors brings to you. Now, last week I explained to viewers that the Family Law and Matrimonial Causes Act, part of it has been there for almost 30 years with this Divorce Dissolution Separation Act 2020, which is coming into place on the 6th of April, or coming into force on the 6th of April. We'll be here to discuss with viewers. And I'm sure most of you who have been following us are now abreast with the law. This is what Citilaw Solicitors brings to you, giving you regular updates of the law under family law, under immigration, under employment. So if you have any family law problem, for example, if you want child arrangement order to see your child, if somebody have lied against you and made application of non-molestation order and occupation order to take you out of your house, we are here to defend you. If you are suffering domestic abuse and you want to make such applications, we are also here to support you. Citilaw Solicitors is family law accredited, and therefore when we are supporting you with your family law matters, you can only dream of the best. If for whatever reason you have suffered injury at work, or you are in a car, you sustained an accident, or you went to the hospital and you felt that that treatment didn't go well, that doctor that did not apply reasonable care and skill and the procedure required under law and gave you something else, clinical negligence or medical negligence, or you had that injury at the workplace, you went to that shop floor, it was so slippery that you slipped and fell and broke your knee. Citilaw Solicitors is here to assist you with your no-win, no-fee compensation claim. And I always say that when people are involved in these accidents, please make sure that it's recorded in the accident book. If possible, take a snapshot of it. Please take a picture of it or insist on getting a copy. Because sometimes when people come to us and we are making these claims, most times they are denied. And sometimes they will even say that they don't have CCTV in that area. So we do these programs to make people aware. Because some of these injuries are permanent. They cause disability. They affect people's earnings for life. And these people are entitled to compensation, which is paid not even by the employer, but by their insurer. Those who have insured them against this liability. So please, if you ever had any problem with accident, don't go far. Citilaw Solicitors is here to assist you. Commercial dispute and civil litigation or dispute resolution. If you have any problem with, for example, someone is owing you, he doesn't want to pay, and you want that person to be chased and that debt to be recovered for you, we'll be here to assist you. Somebody has taken you to the civil court for reasons not valid, we'll be here to defend you. Some clients that were dealing with their case have been taken to court for almost 36,000, something he never owed. And most time, the saddest part of it is that these orders are made and registered against those individuals, which affect their credit rating, sometimes for 6 years. Don't go far. We'll help you to clean that credit file, to get that order off your record. And obviously, if you are having housing disrepair problem, if you are being evicted unlawfully, Citilaw Solicitors is here to assist you to claim that compensation that you deserve, again on no win, no fee basis. If you have a consumer law problem, if that insurance company is trying to wriggle out of the claim and they don't want to pay you. Citilaw Solicitors, we are here under the consumer law to assist you. We are so abreast with the consumer law, such that just a few days ago, I was dealing with a case involving somebody whose insurance company doesn't want to pay. And the reason they don't want to pay is so ridiculous. And that is why we create this awareness for you to know who to turn to in your times of trouble. So tonight is been privileged having you on board. I've not had anybody to have any question, which means that the program has gone very well. So I'm very grateful to all of you who joined tonight and who have been watching. And obviously on Thursday we are going to continue the show. MC Chaka will be here for us to have the tree section. And I'm sure that most of you will want to understand this show in the tree language. So I'm going to make sure that we have the tree section so that people can benefit this immense program that I brought to you tonight. So I want to thank everybody who has joined us tonight, and may God richly bless you. Thank you.